Okay, in this presentation, I am presenting on the topic definition of transfer of property and competency to transfer. Hmm. It is provided in Section 5 of the Transfer of Property Act 1882. Hmm. Now, transfer of property, it means an act by which a living person conveys property in present or in future to one or more other living persons or to himself. Hmm. And to transfer property is to perform such a. Now, these definitions we got. Now, the analysis of these definitions. Yeah, transfer of property is an act. It means transfer of property is an activity or a process. Uh, there is some process between the transferor and the transferee, between the seller and the purchaser. Transferring of property would mean doing of this act or performing such act and between the transferor and the transferee. Yeah, this act or activity must be done between the transferor and the transferee. It provides about some rights, some obligations between the transferor, transferee, and a common word between the seller and between the purchaser of such property. Yeah. Now the living persons. Transfer of property is to be made by a living person. Transfer of property is to be made by a living person. The living persons, that is the transferor, must be in existence at the time of making of the transfer. The living persons, it means at the moment of the transfer, the transferor must have to be existence. That is, this transferors, this transferor person must be living at the moment of the execution of the transfer. Now the conveys. Here, in transfer of property, the living persons, that is the transferor, conveys the property. That is, the transferor who is existence at the time of the execution of the transfer. He will convey, he will transfer the property. Here, his conveying is doing of the act, which is called transfer. Conveyance means any act of the transferor by which certain new titles or interests are created in favor of the transferee to whom the property is being transferred. Now, this act of conveying, this will create some new titles, some interest on the transferee, that is the on purchaser. That is, it must be done by the conveyance, by transferring such property which is under consideration of the execution of transfer. In present or in future, a transfer of property may be made so as to take place with immediate effect or to take place on a future date. And this transfer of property, it may be take effect immediately or It may be take effect on a future date. There is now the property. It has a very wide meaning and includes properties of all descriptions. It means a movable property. It means movable properties such as cards or tables. It means immovable properties such as lands or houses. It also means intangible properties such as the right to catch fish or an actionable claims or other beneficial interest in a property. Here, the concept property has been given in wide concept. It may be tangible property which can be seen. That is, it may be cards or tables. It may be immovable properties, like the lands or houses, or it may be some intangible properties, which are actionable claims or other beneficial interests in a property. It comes under the concept of property, under the definition of the transfer of property. And to another living person, here there must also be another person to whom the property may be transferred. Such other person is called the transferee. Since transfer of property, as defined under Section 5, is an act between the two living persons, the transferee must also be living persons. At the moment of transfer of property by the transferor, the transferee, that is to whom the property is transferred, this person must also be living at that moment of execution of the transfer deed. The transferee need not be a competent person. Yeah, the transferee need not be a competent person. That is, transferee may be minor, incense, or even a child, and venture, uh, or even a child in venture shamir. That means a child in mother's womb. But the transferee must be in the existence when the transfer is made. Yeah, the transferee, that is the to whom the property is transferred, he may be incompetent due to the minor, due to the instance, due to the children, due to the child, or due to the mother's own, that is. But their existence at that moment must be considered in the eyes of the law. That is, yeah, the physical existence at the moment of the execution of the transfer deed is necessary. Yeah, to himself. Here, the word to himself were added to these sections by the Amending Act 1929. By the Amending Act 1929, to include in the transfer of property also a case where a person makes any settlement of his property in a trust uh, and appoint himself as the sole trustee. Here, the transferor and the transferee are physically the same persons, but as the transferor, he has the legal status of settler, whereas a transferee, his legal status is that of a trustee. Here, under the concept of the transfer of property, here the property can be transferred to the transferor himself. It comes under the concept of the creation of the trust property. Here, the transferor, who is the author of the trust, by transferring, he can become the trustee. He can become the transferee, who has been holding under the trust property as a trustee. Here, that's why this transfer of property, it is by amending Act of 1929. Now, it is applicable. Then, the property can be transferred to himself at the moment of the creation of the trust. He can be transferred and he can be transferee. That is. Here, now the section C, next part about the competency of the transfer. It provides under section 7. Here, section 7 of the Transfer of Property Act provides a person competent to transfer. Here, section 7 of the Act provides for the competency of a transfer. Under this section, a person is competent to transfer a property if he is competent to contract, and secondly, is entitled to transfer or is authorized to transfer the property if not his own. Here, if the person is competent to contract and if the person is authorized to transfer, although he is not owner of such property, then such person has a competency to transfer of this property. That is, here, competent to contract. Here, according to section 11 of the Indian Contract Act 1882, 1872 Indian Contract Act, a person is competent to contract if he is of the age of maturity, of sound mind, and is not otherwise disqualified from contracting by any law. A person who is competent to contract is competent to transfer of a property. Yeah. A person who is competent to contract is competent to transfer. Here, entitled to transfer, authority for transfer. The transferor must be entitled to transfer the property, conscience. He is entitled to transfer the property if he has a title of the property, or if he has no such title, has got the authority to transfer it. If a person is transferring absolute interest, he must have ownership in the property. If a person is transferring absolute interest, he must have ownership in the property. Yeah. In case of the transfer of property, if the owner, if he wants to transfer the absolute interest of such property, then he must have the legal title of such property, of such subject of the property. Yeah, the authority to transfer the property is given under the power of attorney. Thus, under authority of a power of attorney, Any person may be authorized to transfer a property which is not his own. Hmm. Yeah. Whatever the power of attorney, he will transfer the property. Hmm. It comes under the concept of the persons can transfer whatever the property may not be of his own property. Hmm. Here, other instances where a person is authorized to transfer the property, not his own, or the manager of a joint Hindu family, in the case of legal necessity. Hmm. A guardian of any minor appointed under the Guardians and Wards Act, an executor or administrator having authority to transfer the property of a deceased under the Indian Succession Act. Hmm. It may be noted that in these cases, the transferor's right of disposal has been defined and limited by the personal laws or statutory laws. Now, here, the persons who can transfer, although they are not the owner of the property. Here, these instances we could see at the moment of the transfer by the power of attorney, and the manager of the Hindu joint family property, hmm, and by the executor or administrator, hmm, appointed by the court. Here, these persons they have to exercise such powers. They are competent to transfer such property. Whatever for given under the personal laws, uh, in case of the manager of Hindu joint family property, and in case of the executor or administrator or power of attorney, whatever the statutory has been given, has been provided powers to such executor, to such administrator, to such power of attorney. Here, their powers is defined and limited by the provisions of the personal laws or statutory laws. Now, these persons also can transfer the property. It comes under the concept of the competency to transfer of property. Here, after this, we have been clearly discussed. We have got a clear concept about the definitions of transfer of property, and the competency to transfer. Okay, that's all.